Dear Mr. President, dear colleagues, ladies and gentlemen, thank you very much for your kind introduction. It is a great honor and pleasure for me to be able to speak today at least virtually, to this important Congress of the Korean Institute of Criminology and Justice. I'm really pleased to say that you have chosen a highly topical and incredibly important subject, which, at least in Germany at the time, has been subject to little discussion so far. Fortunately, I have had the opportunity to devote myself more intensively to this topic recently. It is about the role of criminal law in tackling the climate crisis. Hence, I will take the opportunity to talk about whether and to what extent a potential climate criminal law can be a legal concept for the future. The discussion about climate change has reached deep into society's consciousness and permeates wide areas of science and politics, which is currently also shown by the controversial reactions to the 26th UN Climate Change Conference in Glasgow. It is striking that criminal law has so far not been accorded a significant role in this central question of human history, presumably mainly given the fundamental concerns about the penalization of climate damaging behavior. I would like to resolutely counter such reasoning in my presentation today. First, some remarks on ecocide, as already mentioned. There have been repeated calls for the introduction of a so-called ecocide offense at the international level since the 1970s. Roughly speaking, ecocide is intended to protect the global environment from serious damage, even in peacetime, and to define the environment as such, detached from anthropocentric legal interest as a protected good under criminal law. Especially at the present, there are again recognizable efforts to this end. In July, France decided to introduce an ecocide defense, which, however, only covers intentional environment pollution and has therefore been described by many as unsatisfactory. Another prominent example is the NGO Stop Ecocide Foundation, which is actively seeking a definition of ecocide that might meet with understanding in the international community. A panel of experts led by the international law expert Philip Sands was established and presented a proposal for a formulation of ecocide in June this year. Currently, destruction of the environment is found within the section of the Rome Statute on War Crimes in its Article 8 as an act modality. It remains to be seen how new attempts to subsume damage to the environment under the existing anthropocentric core crimes will develop. For example, the complaint filed by the NGO All Rise with the Office of the Prosecutor of the ICC on the 12th of October this year, due to the destruction of the Amazon region by the president of Brazil, Jair Bolsonaro, which was based on the offense of crimes against humanity under Article 7 of the Rome Statute. The introduction of ecocide is above all intended to represent a symbolic change. In addition to the protection of the entire environment, it is above all associated with the hope of being able to prevent severe climate damage. Since, on the one hand, the hope of being able to prevent severe damage, since on the one hand, the atmosphere itself is part of the environment, and at the same time, climate change also causes and will cause severe damage to the rest of the environment, the pollution of the atmosphere would probably be classified as an extremely important offense modality of ecocide. The offense of ecocide, however, encounters multi-layered criticism. In addition to the systematic concerns regarding implementation at the level of the Rome Statute, there are numerous discussions, above all at the level of content, especially regarding the definition of the protected interest, the requirements for mens rea, as well as regarding the design of an additional restrictive element for the impunity of socially beneficial conduct. Often, however, the substantively important debate is displaced by the conceptual criticism of the designation of ecocide. The conceptual parallel to genocide is criticized primarily because of the danger of playing down the offense of genocide, which could of course be avoided, in my opinion at least, by renaming the offense, for example, as crime against the environment. As to be expected, therefore, the emergence of such a new type of criminal offense also faces difficulties, above all, at the political level. All this, however, should in no way delegitimize the project as such and its exemplary significance. Despite the proactive functions of international criminal law and its fundamental independence from a public administrative law, the determination of the threshold values within the ecocide offense is a major challenge. The introduction of ecocide could certainly create a global change in consciousness that could steer the international focus towards an independent protection of the environment, and thus also represent a prelude to a more far-reaching criminal climate protection law. Taking into account the existing concerns and the already difficult situation of the ICC, the introduction of an ecocide offense still seems a long way off, in my opinion at least. It is therefore obvious to first turn to perhaps more realistic goals, the addition of a new type of climate crime offense to national criminal law. In particular, the multiple parallels between ecocide and a national criminal law will lead to similar obstacles in their development. What are the key objections to the application of criminal law to the climate issue? On the level of national law, there has not yet been a call for a possible involvement of criminal law in the field of climate change. There are two main reasons for the weak role of criminal law in the field of climate change. These are based on the one hand on the dogmatic difficulties in attributing concrete consequences of climate change to the climate damaging behavior of individuals, and on the other hand, on the social utility and supposed indispensability of such behavior. First, the attribution objection and the globality of climate change. Anthropogenic climate change is based on the intensification of the natural greenhouse effect by increasing the concentration of greenhouse gases in the atmosphere. Since the beginning of industrialization, the concentration of greenhouse gases in the atmosphere has increased considerably. The carbon cycle, which was balanced in pre-industrial times, has been thrown out of balance in the course of an increased release of carbon dioxide stored over thousands of years. In addition, there is also an increased emission of other long-living greenhouse gases. The dangerous consequences of the resulting global temperature rise mean that the possibility of emitting greenhouse gases has normatively reached its limits. From nature's perspective, the atmosphere can only be loaded with greenhouse gases to a limited extent and is therefore to be classified as a limited good, the usage of which has currently flared up a global resource dispute. There is a threat of serious overuse since the atmosphere cannot be concretely assigned to any state authority and certainly not to any company or private individual, while the latter profit greatly from the increase in the greenhouse gas concentration of the atmosphere. The prevention of climate change is thus a global challenge that cannot be solved by the isolated actions of a single actor. In view of the global nature of climate change, at first glance, the traditionally nationally oriented criminal law appears largely powerless. Indeed, prima facie, it seems obvious to see the relevant violation in the far-reaching and often dramatic consequential damage of the climate itself, which ultimately also affects or destroys elementary individual legal rights, such as life, limb, health, property, or freedom. Legal rights whose protection is regularly entrusted to criminal law. Even though there can be no doubt that climate change as such can be traced back to human action, the justification of the criminal responsibility of an individual for its consequences has so far posed dogmatically near insurmountable difficulties. This is largely due to the difficulty to prove that a single individual behavior is a conditio sine qua non for a certain consequential climate damage. In addition to causality, German criminal law requires an additional normative limitation of the individual's responsibility in the sense of objective imputability. For this, the perpetrator must create a legally significant danger, which is realized in the success of the offense in its concrete form. However, it is difficult to establish that the behavior of individuals causes concrete climate damage in a causal and objectively attributable manner. Although there are various attribution models in climate science, these are not sufficient for the objective attribution theory of criminal law. Even the first prerequisite of objective attribution, the creation of a legally significant danger, is questionable if one wants to capture everyday behavior of individuals. It is only the accumulation of all the greenhouse gas pollutants in the atmosphere since the beginning of industrialization, which for themselves constitute harmless behavior, that causes global climate change and its far-reaching, ultimately also individually harmful consequences. So second, the aspect of the social utility of climate damage behavior. However, the considerable societal benefit of climate damaging behavior and its supposed inevitability also make the applicability of criminal law seem incapable of consensus from the outset. Society is obviously unable to force itself to fight something that is useful and necessary for it, at least in the short term, especially if this would reduce its competitiveness in global comparison and give that the consensual climate damage is by no means immediately equally noticeable worldwide. At the latest, since the beginning of the industrialization, climate damaging behavior has become part of the central foundation of the global economic order. In national legal systems, however, the social usefulness of climate damaging behavior is limited by administrative law. Criminal law has at best been assignated a supplementary function. Correspondingly, and this is key, the emission of greenhouse gases is not punished as a matter of principle, but only if it exceeds what is permitted under administrative law. In this case, criminal law can only be conceived as an accessory to administrative law, as is the case with current environmental criminal law. For this reason, it is partly condemned that the object of protection in these cases is not intrinsic to the matter itself, for our matter, to the climate, rather merely the climate as shaped through administrative law. It is therefore not surprising that climate criminal law has so far not played a central role in science and legislation, as it is unable to set any independent preventive and regulatory impulses. So what are the central justifications for a climate criminal law? Despite these fundamental objections, criminal law will not be able to ignore the issue of the protection of the global climate in the long term, and may even have to assume a far more prominent role than we can suspect today. Above all, it is the following central considerations that make the combination of criminal law and climate protection seem possible and in the end even indispensable. First, the global atmosphere has to be considered the starting point for the protected interest in criminal law. A necessary holistic view opens up possibilities to go beyond a traditional understanding of criminal law and to envisage new constructions of criminal legal protection which consider the inherent globality of the phenomenon of climate change. In particular, a reconsideration of the object of protection and the offense of climate protection under criminal law promises to be able to effectively counter the central attribution objection. Every single increase in greenhouse gas concentration contributes to the long-term damage of the global climate. Climate scientists calculate that the world has only a very limited budget of carbon dioxide equivalents left to reach a maximum global warming of 1.5 degrees with a significant probability. Even before this threshold is crossed, extreme temperatures and more frequent or intense precipitation and droughts could occur in many regions. A 1.5 degrees warmer world on average will lead to even greater temperature increases in some regions, the so-called overshooting, with possible damage to ecosystems, whereas regions in the high latitudes are already affected by such overshootings. Likewise, climate science predicts so-called tipping points at which regional and local environmental and climate systems will change abruptly due to advancing global warming. Additionally, a point of no return at which probably unstoppable and self-reinforcing chain reactions will be set in motion. In view of the manifold and despite increasingly precise climate science methods, hardly accessible consequences of climate change, it stands to reason that an effective climate crime law should recognize the greenhouse gas concentration in the atmosphere as a legally protected good as such. The global mixing of greenhouse gases due to their long residence time in the atmosphere argues in favor of understanding the climate as a globally uniform system and therefore not considering the concrete local composition of greenhouse gases on a delimited territory, but the globally average greenhouse gas concentration as a protected good. Although such an approach constitutes the atmosphere as a new type of protected good, it does have similarities but already recognized legal goods in traditional criminal law, such as, for example, the protected goods of soil, water, or air in German criminal law, environmental criminal law. However, the atmosphere should not be included in the canon of environmental offenses just as another environmental medium. Rather, the atmosphere as a basic prerequisite of the ecosystem of the Earth is structurally upstream to the classical environment media themselves. Classic environmental media also regularly have a transnational character by their very nature. However, the main difference between climate and environmental criminal law is that only climate criminal law provides for a genuine global object of protection. If the atmosphere is the object of protection of a climate criminal law, any pollution of the atmosphere, any positive emissions can be considered as a possible offense. This includes both the release of greenhouse gases and the interference with natural sinks, for example, in the form of deforestation. The extraction and use of sustainable raw materials must be excluded, which could be solved by a construction of intent that excludes sustainable use from the offense. Further consideration could also be given to the protection of the atmosphere under criminal law through upstream and downstream criminal offenses, for example, penalizing the extraction of fossil fuels as an abstract endangerment offense, or the subsequent consumption of products provided in a way that is harmful to the climate. However, all these considerations do not absolve us from carefully examining the punishability and need for punishment of individual climate damaging behaviors. The fundamental requirements of the rule of law, in particular the principle of proportionality and the principle of ultima ratio, must always be respected. Given these considerations on the atmosphere as the subject of protection, it only seems conclusive to assume that the relevant effect of any climate offense should be the increase of the average greenhouse gas concentration leading to climate change itself. Such a normatively relevant increase is ultimately only given if, at the time of the offense, the burden on the atmosphere has not already been adequately compensated. Therefore, an overall balancing of positive and negative emissions seems to be necessary to establish the final consummation of the offense, which also seems to be able to do justice to the cyclical nature of the climate system in the whole world. It should be noted that the basic obligation to compensate does not carry a judgment or decision on the specifics of the compensation, by whom, in what form, Thus, a comprehensive climate criminal law could and would probably lead to at least a partial state takeover of compensation. It is relatively easy to prove causality between the individual's pollution of the atmosphere, the act, and the increase in the average greenhouse gas concentration, the result. Any uncompensated pollution of the atmosphere is in itself causal. As already indicated, German criminal law also requires objective attribution, that is the creation of a legally relevant danger that is realized in the constituent success. In particular, the first requirement of risk creation must be given substantial consideration in the context of climate criminal law, since, for example, greenhouse gases are also inevitably released during the natural vital functions of humans, for example, by breathing. The penalization of such behavior would be clearly disproportionate and would be seen as a clear violation of the attenuation principle, so that restrictions would have to be made here in order to preserve the rule of law. This is the exemption and of neutral actions and a gravity threshold. On the one hand, climate impacts that are to be classified as neutral actions with regard to anthropogenic climate change are to be excluded from attribution, that is, those behavior that have always been part of human life and thus also part of the natural greenhouse effect, and are therefore not the cause of what is understood by anthropogenic climate change. Here one could be guided by climate science. It only includes behaviors that first occurred with the industrialization process and have since become the basis of today's industrialized societies. On the other hand, in the context of risk creation, attribution continues to occur only if someone has created a legally significant danger. In view of this threshold, only slightly invasive, everyday private behavior would need to be excluded from climate criminal law. As an adaptive system, the limits of such normatively shaped pertinence would well shift as the climate crisis intensifies. When assessing the significance, the greenhouse gas potential of the positive emission must be considered. At least at present, trivial acts such as lighting a lighter or keeping a pet would definitely not make it through the attribution test. So my first interim conclusion: the concept of a possible criminal law on climate change outlined here breaks new ground, both dogmatically and in terms of legal policy. In essence, this is ultimately an advanced shift in criminal liability, which is not unproblematic from the perspective of the rule of law. In principle, one should be skeptical of such a far-reaching shift, but in view of the immediate, unprecedented threat posed by the ever-worsening climate crisis, science and legislation should not reject such a shift from the outset. On the contrary, it is precisely the task of jurisprudence to explore new ways of bringing together effective criminal climate protection and the rule of law. The importance for climate neutrality for a criminal law approach, this is one of my major points. Just like the attribution objection, the objection that a criminal law approach is not necessary will not be able to assert itself as an obstacle for the creation of a comprehensive climate criminal law in the long term if the climate crisis continues to worsen. So what is the goal of climate neutrality? The more threatening and costly climate change becomes, the more likely it seems that drastic steps will be taken to effectively prevent climate damaging pollution. What is astonishing is that neither the legislator nor criminal jurisprudence seem to have noticed that such a departure from the utility objection has already taken place. Even more so, the use of criminal law to prevent climate change is already emerging today in the goal of climate neutrality as a pillar of international climate policy, and has already been globally agreed upon as a legitimate means should the climate crisis continue to worsen. The legally non-uniformly defined state of climate neutrality has long been regarded by climate scientists as the goal to be achieved worldwide to overcome the climate crisis, and essentially describes a balanced state between positive and negative emissions, so that the greenhouse gas concentration in the atmosphere is not increased in the long term, which is the state of net zero. In addition to legally binding implementations in a few progressive countries, the European Union recently adopted a climate law, which also provides for the legally binding climate neutrality by 2050. Although the Paris Agreement on climate protection does not set a binding target for climate neutrality, it aims to achieve it in the second half of the century in accordance with Article 4. In addition, according to Article 2, paragraph 1, litera A, the states have agreed on the legally binding target of a maximum global warming of well below 2 degrees. That ultimately results in a legal obligation for the parties to refrain from any uncompensated emissions, so the net zero status, once the warming maximum has been reached or considerably earlier in order to achieve the global climate target. So what are the consequences of the prohibition of uncompensated positive emissions in our context? The legal conceptualization of climate neutrality has not been thought through in detail so far. Rather, the focus of international and national climate policy has been on the reduction of greenhouse gas emissions by means of public law control mechanisms, in particular through taxation or climate damaging behavior and emissions trading. The binding goal of climate neutrality introduces a necessary paradigm shift in the legalization of climate protection. Since in the legal state of climate neutrality, uncompensated emissions may no longer be possible, the necessity of using criminal law to achieve the binding global criminal goals, the binding global climate goals becomes apparently a fundamental ban on all uncompensated emissions is then required. Legal climate neutrality, however, does not necessarily indicate an absolute ban on climate damaging behavior, but rather requires the design of a more flexible climate protection concept away from the current reduction mechanisms and towards a sustainable compensation mechanism. Thus, public law control mechanisms in the form of taxation and budgeting can also continue to be part of the comprehensively conceptualized criminal climate penalty law, for example, through the state organization of individual compensation payments through a sustainable tax policy. So my wider view is on the global jurisdiction and transnational cooperation and its problems. If one recognizes the global atmosphere as a legitimate object of protection of a national climate crime, inevitably the question of jurisdiction arises, which obviously will provoke political problems. As to jurisdiction, according to the principle of territoriality recognized by international law, a state can extend its criminal jurisdiction to all acts that occur on its territory, whereby, as in most legal systems, both the place of commission and the location of success within the country are sufficient for the purpose. A nation state could only extend its punitive power regardless of the place of commission if the principle of universality applies. For this to happen, globally recognized standards must exist, in particular an international treaty or customary international law which establishes certain acts and achievements to be punished worldwide. The application of this principle is, of course, limited to a few severe crimes, which include, in particular, the core crimes of international criminal law. At present, however, there is probably no such globally recognized core offense for either environmental crimes or climate crimes, so that an extraterritorial application of a climate criminal law under the headline of universality principle seems still unlikely. Since the constituent success is to be seen in the increase of the average greenhouse gas concentration in the atmosphere, the location of success is of a global nature, thus coming back to the internationally recognized principle of territoriality, a further consideration would be to assume global jurisdiction by establishing a truly global place of violation. For this to be the case, it would have to be possible to prove that the effects of climate offenses, the increase in the average concentration of greenhouse gases in the atmosphere, at least also occur on the territory of the penalizing state. The sovereign territory of a state also includes the airspace above its landmass. The specific height of the airspace covered is disputed under international law, but undoubtedly includes the two layers relevant to climate change, the troposphere and the stratosphere. Since air and atmosphere describe the same thing from a scientific point of view, it would be contradictory if a state were allowed to protect the air circulating above its territory under criminal law, but not the parts of the atmosphere. As a result, if one applies the well-known principle of territoriality to climate criminal law, it in principle seems possible to also assume its global application and jurisdictional competence on the basis of the global place of violation. This leads to certain problems. A global responsibility solution, however, reveals significant sovereignty conflicts. Since the beginning of industrialization, greenhouse gas emissions have served economic progress for a long time without at least known consequences for humans and their habitats. In the context of climate justice, special consideration must be given to the inequality between industrialized and developing countries. Penalizing extraterritorially climate-damaging behavior could impair and possibly even prevent the industrialization process of developing and newly industrializing countries, leading to an understandable accusation of neo-colonialism. Moreover, penalization could be used as an illegitimate tool in the war for resources and the use of fossil fuels, perpetuating the economic dominance of industrialized countries. The potential for abuse of global jurisdiction is thus obvious. Although such scenarios may seem dystopian at present, global jurisdiction does not seem too hypothetical in the near future to the different legal and factual circumstances regarding climate change in individual states. There are therefore considerable doubts about the legitimacy of such a far-reaching encroachment on state sovereignty. Current international law seems unable to cope with the inherently global nature of climate, the compatibility of efficient climate protection under criminal law, state sovereignty, and the implementation of climate justice thus describes a considerable area of tension that criminal law scholarship and practice must address in a timely manner. So my conclusion. In summary, the creation of an international offense of crime against the environment is most welcome, but pragmatically and politically difficult. Thus, this can only constitute a solution on the long run. The focus is therefore on national criminal law. In the much proclaimed legal state of climate neutrality, effective climate protection and climate criminal law belong together. Legislators, legal practice and jurisprudence must become aware of the role of criminal law in the prevention or mitigation of climate change, a role that has hardly been perceived so far. The rapid escalation of the climate crisis gives rise to fears that, if not addressed soon, hasty, undogmatic, and ultimately illegitimate conclusions and provisions may be implemented. Increased recourse to prohibitions under criminal law leads, even in an area as important as climate protection, to serious restrictions of central individual liberties, which appear acceptable only as a last resort according to the ultima ratio principle, and despite innovative and interdisciplinary consideration, only with the inclusion of rule of law control mechanisms of a liberal criminal law doctrine. Last but not least, the development of a criminal law on climate change can only be conceived with a view to the community of states. It has to be kept in mind that the atmosphere being considered the relevant protected good of a criminal law on climate change does not belong to one state alone, but to all states together. Thank you very much for listening to me.